Welcome back to the Lost Test channel. My name is Anton Vieltsin and I'm a criminal defense attorney here in the Southern District of California. In this video, we'll be discussing pretextual impoundment, meaning that the police officers are impounding the vehicle simply to find more evidence of a crime. And this 10th Circuit case will also help us recognize that fighting impoundment is not always about the vehicle. Sometimes it can help us get rid of the evidence that will be later used in trial, and it can even dismiss your case. Before we discuss United States versus Woodard, a 10th Circuit case about impoundment, I'd like to remind you that a few weeks ago, I finished a 5-part series dealing with automobile searches without a warrant. We talked about consent, and in fact, we've talked about impoundment and a couple of other exceptions dealing with automobiles. I encourage you to click on the link above and watch that series. It will help you understand when the police can search your vehicle without a warrant. So now let's move on to United States versus Woodard. It's a 10th Circuit case that gives us a good roadmap on when we can recognize pretextual impoundment. So here's what happened in the case. The officers were going to execute a misdemeanor warrant and serve a protective order on Mr. Evan Woodard. So at 8 a.m. in the morning, they conducted a traffic stop. He parked in a parking spot at QuikTrip parking lot, a small convenience store. At that point, the officers made a decision to impound his vehicle because he did have an outstanding warrant for a misdemeanor. Now, at that point, Mr. Woodard asked the officers if he could call his friend who could pick up the vehicle and drive it off the lot. The officers told him no. Instead, they decided to impound the vehicle. They began the search where they found drugs, guns, scales, and from that, they had a warrant to search his cell phone because now they had enough probable cause to ask the judge for a warrant for the cell phone because of the evidence they found in the car. Now, there were 2 sets of charges, one in Tulsa and one in Bartlesville because of the phone. The charges were possession with intent to distribute. How do we know about this intent to distribute? Well, from the phone. We had text messages where Mr. Woodard was selling narcotics to others. Let's move on to the law. The Fourth Amendment tells us that there is a heightened scrutiny when we're dealing with private property. There's only 3 times when the officers can impound the vehicle from private property. If the vehicle is blocking traffic, if the car posing imminent threat to public safety, or when the impoundment is justified by a standardized policy and a reasonable non-pretextual rationale of community caretaking. Now, in this situation, it was parked at QuikTrip parking lot. So it wasn't blocking traffic. It wasn't posing any threat. So now we have to look whether the policy allowed the officers to impound this vehicle. Of course, we know from Caniglia versus Strom, a case that I've previously discussed. And again, I will link it above for you to watch again. But essentially, of course, police officers can perform community caretaking functions. But they have no open-ended license to impound cars whenever and anywhere. And in fact, we're dealing with private property. Now let's move on to the policy. When we're dealing with a policy, the case actually spelled out the policy, but here's what we can gather from it. The only time this department allowed the officers to impound the vehicle is when the vehicle was from public highway or from a private property when the offense was committed on public property. Now, in this situation, the vehicle was not on public way. We know it's in a private parking lot. And the second thing, we know the offense did not happen on public property. What is the offense? Well, it's the misdemeanor, whatever the warrant is for, and we know that that happened on prior occasion. So we know that this offense did not initiate on public property. Before I discuss this case any further, can you do me a huge favor? Can you click the subscribe and like buttons below? And if you live with roommates, yell as loud as you can that you're watching the Lost Tash channel, and hopefully they'll subscribe as well. Thanks for watching. Did you click that subscribe button? I hope you did. Let's move on to the case. The appellate court could have stopped here after discussing the policy by the department, because if we look at the Fourth Amendment, we now know that the first two factors don't apply, and then the third one dealing with a standardized policy, well, we know the policy. The department could not impound this vehicle even by their own standards. But the appellate court goes further, and it discusses pretextual impoundment, meaning that even if we say that this impoundment was legal under the department's own policy, could it still be pretextual? And the answer is yes. We look at the 5 factors. The first one, whether the vehicle was parked on public or private property. And in this situation, we're leaning toward pretextual stop or pretextual impoundment because the vehicle was parked at a private parking lot. The second factor, whether the property owner was consulted. And here the answer is no. None of the officers ever went inside the Quick Mart to see whether the clerk would allow the person to leave the vehicle there or if they required impoundment. The third factor, whether alternative to impoundment existed. And in this situation, we know that they did. In fact, Mr. Woodard asked the officers whether he was allowed to call a friend who could pick up the vehicle. Now, there is some question whether the officers have a duty to ask the person that they're arresting whether he wants to call someone. The court doesn't go into that question here because none of the parties raised it. Instead, they say that the answer is yes, there were alternatives because in fact, Mr. Woodard himself asked for an alternative. The fourth one, where the car itself is implicated in the crime. And here, no. It wasn't implicated. The crime was the misdemeanor, and so the answer is this was a pretextual stop or pretextual impoundment. And finally, the fifth factor, whether the driver or the owner consented to impoundment. And this one's clear. Of course, Mr. Woodard did not allow the officers to impound the vehicle and later search it, under that exception to the warrant requirement. And finally, the court looks at the statements by the police. This is why it's important for your attorney to always watch all of the body camera footage. Because in this situation, the officer told Mr. Woodard that he was going to light him up for whatever he can. Meaning that he was trying to find whatever evidence he can see inside the vehicle to build up the case against him. And in fact, there were 2 cases in 2 different cities. This brings us to the exclusionary rule. Hopefully you watched my video from last week dealing with exclusionary rule. This is the rule that tells that any evidence found in violation of the Fourth Amendment should be excluded from trial, cannot be used against the defendant. And in this situation, the court says that both cases in both counts and all counts should be dismissed. Because after all, the only way that the government was able to prove intent to distribute was from the text messages. If he would have been simply charged with possession of the drugs, he might have been able to be convicted. But in this situation, it's the intent. And the only way we see this intent to distribute is from the phone. And the only way we got to that phone is from doing the illegal impoundment, finding all that evidence to later get a warrant for the phone. And because the phone and later whatever is found were fruits of the poisonous tree, that evidence should be excluded from trial. And that's exactly what the court says. So this is a good lesson that teaches us that impoundment is not always about vehicles. Sometimes we fight impoundment because it actually helps the case. And in this situation, the court says the case should be dismissed in both counts. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.